Remember the mom who wrote that children's book about grief a year after her husband's tragic death to help her boys deal with his passing, only to be arrested for allegedly offing that very husband. Well, Kouri Richins' case is going to trial in just a couple of months. There have been some updates, and we will cover those in this video. A lot of cases coming up in 2025 that are going to trial in 2025. So it's going to be a busy year for the channel. If there's ones that you are aware of that I haven't talked about, well, let me know. If you want me to continue following Kouri Richins and some of these others, let me know that too. So if you're unfamiliar with this case, Kouri Richins is the young mom from Kamas, Utah, whose husband died of fentanyl poisoning, and she declared it was an accidental overdose. She published a children's book about grief to help her young boys deal with the death of their father. And then a few months after the book came out, she was then arrested for his homicide, for lacing his drink. They said some people have said it's a Moscow Mule. Turns out it was not. It was some other kind of drink. Not that that really matters, but I like the accuracy. It was not a Moscow Mule. It was something else. But there's evidence that she also tried to off him on Valentine's Day a few weeks before that, and by lacing his sandwich with fentanyl. And he apparently didn't eat enough of it. He took a bite or two and got sick. And some of the texts between them that day are really disturbing. She was hoping to be with her new boyfriend, not expressing much concern about him, saying, "Oh, just take a nap, I'm sure you'll be fine." But then she realized that a sandwich wouldn't do it. She was able to get more of the illegal substance and put it in his drink, and then he drank it all, and that did him. Those are the basic alleged facts. The alleged case we're looking at with Kouri Richins. In November, her attorneys tried to get her out on bail yet again. The judge said, no, not happening. No surprise whatsoever. In that same hearing, though, the judge dropped a couple of drug distribution charges that were part of the case. He also took 4 felonies and severed them from this trial. Those ones are related to mortgage fraud and forgery that were involved with Kouri's real estate business, where she would buy and flip houses. He says that those charges were different enough from the homicide charges that they should be in their own trial. So I imagine she'll be tried on those charges after the homicide case has wrapped up. At that point, also, both the prosecution and defense wanted to expand the jury pool, bigger than Summit County, which is where the trial is currently stated. Everything is happening in Summit County at this point. Summit includes Park City, but also a lot of ranch types areas and national forest type stuff. So Ballerina Farm is up there. We'll have to link to that playlist. So it makes sense that they would want to expand it because this case has gotten so much attention. And it sounds like the judge and state and defense all want to expand the jury pool. So the judge said, sure, let's do that. Let's expand the jury pool from Summit County to also include Salt Lake County. But then a higher district court judge in December said, nope, you can't do that. The law isn't written to allow that. You're allowed to draw from a different county from your own, but not from multiple counties, as the law is currently written. So they appealed that. It seems like everybody wants this, but whether it's technically allowed within the law right now is the big question. February 11th, the Utah Supreme Court actually heard arguments about this particular case and that issue, and we have yet to hear a response or a decision on that. My suspicion, this is just my non-professional, non-legal opinion, is that if they are allowed to pick only from one county, they will probably pick from Salt Lake and drop Summit, because Salt Lake is a much larger county with a much more diverse population. And so I think they would probably, my guess would be that all sides would prefer to draw just from Salt Lake if they can only draw from one. Also early February, February 3rd, the pretrial hearing there were, again, all sides are concerned with getting an impartial jury for this case. So one thing they've decided to do is, instead of having on the early surveys be yes or no questions, they will have rankings from 1 to 5, so that it's not just a blanket yes or no. They can get a more nuanced response, and they feel that that will enable them to get a more unbiased jury. Well, that was kind of cool. They will have, I think they said about 1,500 surveys. They'll whittle those down to 200. And then there's also some question about whether they will be choosing the final jury in person or, say, via Zoom type situation. I don't think that's been decided for sure yet. And then on February 12th, the defense files a new motion, and I just want to just slap someone. To me, this feels like they're just playing cheap games. They want to reopen evidence and reopen questioning for at least 4 witnesses. And their reasoning, it doesn't seem to make a whole lot of sense. Apparently, her attorneys are questioning, quote, at the very least, the accuracy and quite possibly the truthfulness, unquote, of the lead detective's testimony. Apparently, the prosecution snapped back with, okay, you think it's shocking that he doesn't remember insignificant at the moment details that occurred nearly 2 years earlier. And then he goes, poppycock. That was pretty awesome. The discrepancy between those two people as they were preparing for that hearing, and they had an outside attorney investigate it. And so Bloodworth, his legal filing said that they told Richins' attorneys about it, this discrepancy, on January 31st, provided them the report from the outside attorney on February 6th. And the report said that there had been no evidence that the recollections were inappropriate or that either detective was not truthful. They told Kouri's attorneys that they would be fine reopening evidence if it was deemed appropriate, if the outside attorney were to present his findings and say that, yes, this was needed. But at this point, they're saying it sounds like you want to just reopen things for the sake of just playing litigation games, and that's not how these are supposed to work. But Richins' attorneys want to get certain statements that were made by the lead detective suppressed in the trial. From what I've gathered in various articles, it sounds like there are 2 detectives who remember, as the prosecution called them, insignificant at the time details, slightly differently. But that doesn't mean they're lying, and it doesn't mean that they're wrong, especially if they're insignificant, inconsequential details of whatever they're talking about. We don't know, but they say it's kind of upsetting that they're questioning the detective's character without citing any facts. The response said the defense counsel's feelings do not matter, objective facts matter. Part of the objection, this is from KSL, Richins' attorney told the prosecutors they feel that O'Driscoll testified untruthfully, specifically when he testified that he did not think he knew Richins was represented by an attorney when he went to her home and spoke with her for multiple hours. So at this point, it kind of feels like a he said, she said situation. According to Bloodworth's legal filing, Richins' attorney also cited that O'Driscoll was prepared for questions from prosecutors, but would respond that he did not recall to many of the questions from Richins' attorneys. And I'm not sure why it's a big deal that someone would be prepared to here's the questions, here's the information that we will be asking you about. That seems like a pretty typical, that's not coaching, that's just preparing a witness. I don't see anything nefarious about that. But said the Richins' attorneys did not talk to the prosecutors before filing their motion because they just wanted publicity to bring doubt to the testimony of the lead detective on the case. So he asked the judge to deny the motion, allowing the process to decide what evidence should be shown at trial to move forward, as according to KSL News. So as far as I know, the judge has not yet ruled on the motion. So for the moment, the trial is still slated to begin on April 21st. It was supposed to begin on April 28th with jury selection, but both sides in November said, oh, we're going to need more time, and Kouri might be testifying herself as well, and that would add more time that we need. So they actually added an entire week. So instead of April 28th, they moved it back to April 23rd, or moved it up. However you say that. April 21st at this point is when it is slated to begin with official jury selection. And assuming we don't have any more delays, assuming this motion gets denied or whatever, we shall see. So the next pretrial hearing will be Friday, February 21st. We'll see what the judge rules. We'll see if the Utah Supreme Court has made a decision about the jury situation. So thank you if you're still here. I really appreciate it. Give this video a like and a follow if you are new. Let me know what you think of this case and where you think it's going, what other cases you'd like me to cover. And while you're in the comment section, drop off some chocolate emojis and or your favorite comfort food of choice, so we can all have something to nosh on as we chat true crime in these cases that we cover. And until next time, pass the chocolate.